Hello everyone, today I'll be sharing another legal story with you. So basically on 20th September 2025, the Supreme Court was dealing with the case of Lakshman Jangade versus the state of Chhattisgarh. Okay, so let's first understand what happened in this case. So basically certain allegations were made against the accused. Okay, and the allegations were that he touched the private parts of the victim whose age was below 12 years, and simultaneously he was touching his own private parts. Okay, so allegations were that he touched the private part of a girl whose age was below 12 years, and simultaneously he was touching his own private parts. Okay, later on the trial court finds the allegation true. Okay, and they decided to convict the accused, right? And they convicted the accused for period of 20 years, that too for rigorous imprisonment under section 376 AB of IPC and section 6 of POCSO, right? This decision of the trial court was affirmed by the High Court also. Okay, so both the trial court and High Court were on the same page, right? And both upheld the conviction under section 376 AB of IPC and section 6 of POCSO. What section 376 AB of IPC is talking about is basically it talks about the punishment for rape of a woman under 12 years of age. Okay, and section 6 of POCSO talks about punishment for aggravated penetrative sexual assault. So section 6 provides punishment for aggravated penetrative sexual assault. Okay, aggrieved by the conviction, the accused filed an appeal before the Supreme Court. So accused reached Supreme Court. Okay, he filed an appeal there. Okay, while hearing the appeal, the bench observed that the assumption of a penetrative sexual assault. So since the accused was convicted under section 6 for aggravated penetrative sexual assault, so the court said that the assumption of the penetrative sexual assault by the trial court. Okay, and later, because the same decision was the same decision of conviction under section 376 AB and section 6 of POCSO was affirmed by the High Court, so the assumption by both the trial court and the High Court is not sustainable, right? Is not sustainable. And the reason it is not sustainable because the medical reports, victim statements and her mother's testimony do not support such assumption. So such assumption is not supported by the record that is present before the bench. Okay, the court held that on reading evidences and other medical record, they do not satisfy the ingredients of section 375 of IPC and section 3 of POCSO. Okay, so on seeing the record, at the bench observed that it do not satisfy the ingredients under section 375 of IPC and section 3 of POCSO. Section 375 of IPC, it provides definition for rape, what is rape, and section 3 of POCSO, it provides for penetrative sexual assault. Therefore, the court said that merely touching the private parts of a victim whose age is below 12 years, it will not constitute an offence under section 376 AB and section 6 of POCSO, right? Section 375 defines rape, and since ingredients of rape is not fulfilled, then section 376 AB, which talks about punishment for rape of women under 12 years of age, since the offence of ingredients of rape are not fulfilled, the liability will not be established under section 376 AB. Okay, similarly the case with section 6 is also not maintainable because the ingredients of penetrative sexual assault are not fulfilled, and section 6 provides for punishment for aggravated penetrative sexual assault. So since the ingredients are not fulfilled, the liability or the offense under section 6 will not be constituted. Okay, the court clarified that such conduct by accused will constitute aggravated sexual assault under section 9M of POCSO and offence under section 354 of IPC for outraging modesty of a woman. So, right, so court clarified that the conviction under section 376 AB of IPC and section 6 of POCSO is not maintainable, but actually the conviction will be under section 9M of the POCSO, which talks about aggravated sexual assault on a child below 12 years of age. So conviction will be under section 9M of the POCSO, and offense under section 354 of IPC for outraging the modesty of women. The court convicted the accused under section 354 of IPC, that is for outraging modesty of women, and section 10 of POCSO. Section 10 of POCSO provides punishment for aggravated sexual assault. Okay, so which after the fulfillment of section 9M of POCSO, the court upheld the punishment under section 10 of POCSO and under section 354 of IPC, and therefore since the trial court and the high court, they convicted the accused under 376 AB of IPC and section 6 of POCSO, which are more heinous offenses. Okay, so after the clarification, since the accused was convicted under section 9M of POCSO and section 354 of IPC, the punishment was reduced to rigorous imprisonment for 5 years under section 354 of IPC and 7 years under section 10 of POCSO, which will run, and these both punishment will run concurrently, and the fine of 50,000 was retained as per the decision of the trial court and high court, with a direction that this to be paid to the victim as compensation within 2 months. So the fine that was imposed, that has to be paid via compensation to the victim within 2 months. Okay, so this is what happened in the case. Thank you so much.